Hello and welcome to ViEUws.eu and our discussion on the GDPR, the General Data Protection Regulation. We're going to look at the state of play and ahead to how it's going to be implemented. And of course, the devil is, as always, in the details. Joining me to talk about that, we have Jan Philipp Albrecht, the rapporteur here from the Parliament involved in the trilogue negotiations, and Wojciech Wiewiórowski, who is from the EDPS, the European Data Protection Supervisor's Office. So let's start with that first question. Jan, give us an outline where we are. You set a very, very tight time frame for getting what is a huge piece of legislation negotiated. Was that a tactic? And if so, is it successful?
It's not a tight time frame as we look to the fifth year of the negotiations, and the heads of states set this timeline in 2013. That's quite a time ago, and I think that now we should really deliver on it. Also, the President of the Commission, Jean-Claude Juncker, in his priority paper has set this timeline. Of course, after the Council taking quite a time to their general approach, we now have just some weeks left to get this timeline also done. But I'm very optimistic that there is a good opportunity to close with a political agreement before Christmas.
Well, you started the negotiations with, as you say, the Council in the summer. And it seems like you went for the low-hanging fruit first, the easy chapters, the easy articles. So does that mean you've been left with all the difficult stuff now in the final weeks?
It's not that we didn't touch on it, but of course it's easier and mostly also quicker to agree on things where the text even perhaps mirrors each other on both sides, or where priorities are not that high. That means, of course, that we still are struggling to find compromises on some of the core issues, namely, for example, on the mandatory data protection officer, which always has been a difference between both in approach, namely also on the question how we formulate requirements for consent and the possibilities to process data apart from it. So those debates still are ongoing, but it's not that we didn't have any step forward in those areas. It's also that we are moving towards each other, but the final compromise still has to be found.
Wojciech, let me turn to you, because the EDPS put out its own position, if you like, a fourth way between the Commission, the Parliament and the Council. I mean, you've been obviously following the negotiations closely. How close do you think it's coming to the EDPS text?
Well, first of all, let me say that I'm also quite optimistic about the actions which are done at the moment, and I believe that next spring we will have the text ready. Well, of course, the suggestions from the European Data Protection Supervisor, that's not an official text which is taken into consideration during the trialogue, but I guess in many situations it's taken into consideration by those who are at the table as a voice from outside of the discussion, and voice which tried to choose among those texts that were proposed by three participants of the trialogue the path which will be somewhere in the middle. And I hope it's useful. We also did it a little bit different than we usually do. So we didn't only provide the text, but we also prepared a mobile application in order to help the people to deal with three texts and some additional suggestions. Definitely not all the suggestions will be taken into consideration. That's something that we are absolutely sure. On the other hand, the clear voice from Data Protection Authority of the European Union is important in this field.
Okay, well, let's deal with some of these issues that are still on the table. You mentioned the data protection officer, and we have a question in from Twitter, which is asking what laws or regulations will apply to those organisations with fewer than 5,000 records on a database. And this is one of the questions about which businesses it's going to affect. Tell me a little bit about that and where we're at.
So today's situation is that in some of the member states, quite few at the moment, there is a mandatory threshold from where on you have to appoint a data protection officer in your company, in your business. In most of the other member states, in most of the member states, there's not such a mandatory provision. which doesn't mean that in those countries companies are not having these officers. Most of them today know that they need somebody who is into the substance of data protection laws and can look at compliance with these rules in their businesses, and that this is also like an advantage having somebody there. The question is only now, do we make it mandatory for all the member states or not? So it's a question also of harmonization inside the European market. And my impression is that we are coming closer to it. The question will be at the end, of course, which companies will have this obligation and which not, and what is if you're not obliged by it. If you're not obliged, then you may have an officer or you may not. That's the whole issue. And if you are obliged, then of course you have to install such a data protection officer, which in most of the cases doesn't have to mean that it's a full-time post which is like extra only for this, but you can have somebody getting the knowledge on top of his job or in a part of his job, or also external advice doing this work.
I mean, it's also the quality of what they know rather than somebody who's already doing 15 other tasks in a business saying, oh, well, that's for you as well.
Exactly, and that is more the substance of what is to be agreed in the regulation. What is the role of that officer, what's the position of it, and also what knowledge needs to be there, and how can he keep up to the technological development, also legal development here.
Okay, I mean, well, when it comes to enforcement, you will be obviously working, there's the DPAs, the data protection authorities. Now, we could see a sort of an incongruous situation where at the moment there's a data protection directive. So in theory it's applied differently across all the different member states. And we're now moving towards a regulation which people tend to believe is tighter and more narrow. But there's going to be a lot more scope for how DPAs interpret it and enforce it, is that right?
I would like to stress that this part about the coordination of the work between the data protection authorities is actually one of the most important parts from our point of view. I have a lot of experience in dealing with different bodies in the European Union which are composed of the representatives from different countries, and I may say that I was surprised when I joined DPA society how close they are in the way of thinking. So it's already now the coordination was quite well, although the differences of course exist. We have the data protection authorities at the moment who look rather like the ombudsmans, and we have those where the enforcement is actually the main way of doing the things. And definitely the regulation gives us the common background for all of them and the ways to cooperate not only inside the European Data Protection Board, but also on bilateral and multilateral scale. So this part, I guess, is the most important from the point of view of the coordination of the everyday activity. We have to remember that we have different courts in the European Union countries. We have different ways of judicial review also over the decisions of the data protection authorities. So some differences may exist. What is crucial is that the line has to be coordinated, and also in the situations of either negative or positive conflict between the data protection authorities, there is a way to solve it. We can see that some of the decisions of the Court of Justice of the European Union from last 2 years are exactly about the problem of the coordination of the work between the data protection authorities. Let's say, for example, the ViEUws decision from last month, which was exactly about the cooperation between two data protection authorities in the action which is not all European one. That's the bilateral one, that's the one which is important for two countries only.
Well, you mentioned the ViEUws case. This was where a real estate agency, while it was set up in one country, was actually operating and selling and running it in the language of another, and people were very unhappy that their data was misused. You mentioned the EDPB, the European Data Protection Board, which doesn't yet exist. What's that going to look like? Because this is spun out of the one-stop shop idea. And is ViEUws like a test case, if you like, for what we're going to see?
That's one of the test cases, I may say. Several cases that the Court of Justice was ruling last years were actually about this kind of coordination. ViEUws is simply the last example. But it shows very well that the European Data Protection Board is not the venue for all the cases about the coordination. This is not the place where everything can be solved, because this case was actually important only for these two countries that were mentioned there. So EDPB will be definitely the successor of the Working Party of Article 29, but with a big difference, which is that some of the decisions taken by EDPB will be actually binding for those data protection authorities.
Well, let's talk a little bit about time frame, because with these questions that you're raising, what sort of a transition period are we going to see? Because we're also waiting on the directive for law enforcement agencies to come into place, and you've said that you want to vote on those two together. So tell me what can we look forward to?
So first of all, on the regulation, all three texts from the Commission, the Parliament and the Council foresee a 2 years implementation phase, which means after 2 years, 2 years after we have voted officially on it, it will be also effective. Which gives member states also time to implement the Data Protection Directive in the police environment. And the Parliament expects that we are not only voting together regulation and directive at the same time, but also that member states have to implement the directive latest when the regulation comes into effective application.
Okay, well, let's turn now to the fears of businesses. I mean, we're hearing companies say that this is going to break big data and that's going to be a huge knock-on effect for European growth. What do you say to that? I mean, they're worried that the limiting of further processing could actually ruin business models.
I would say let's go back and understand what we are doing here. We are doing a reform which is the harmonization throughout the whole European market. That's the vast reduction of bureaucratic burden for businesses, because you don't have to comply with 28 or even more different standards throughout the member states in the European market. But also we are investing thereby in competitiveness of European businesses, and that are in particular small and medium-sized businesses doing innovation and businesses on the processing of personal data, because we now create a level playing field not only for the European businesses but also for all business coming from the outside to the European market. I think we should see the chance in it and see that this is a huge step forward. But we also have to understand that this is a matter of a fundamental right of each and every individual, and this is also a matter of consumer rights in a digital, completely connected society in which we are. And in this situation, we can't just say we give a gift to the businesses, we reduce bureaucratic burden, and we allow for businesses to be made everywhere without hurdle and on a level playing field. But on the other side, we don't care about the matter of fact that the vast majority of consumers don't trust the application of basic principles and standards of their protection in the internet life, in the digital life. And so we have to show that we care about that and that we implement effective standards to protect their rights. And that means, of course, that we uphold the principles which are there today. My impression is not that we create additional burden to businesses, but we just uphold what is the principal basic protection of the fundamental right of privacy and data protection already today. And I think that's not something illegitimate, but something which should be welcomed by businesses also, because it creates the trust which is needed for consumers to also buy their products and services.
And I think that sort of answers one of the questions which we had from Twitter, which was, what do you think the privacy consequences will be to benefit data subjects? Wojciech, do you want to give us your take on that?
Well, definitely big data means big responsibility, and the bigger the data is, the bigger is the responsibility. But responsibility which is not understood as the possibility to be enforced for bad activities that you do, but responsibility which means the accountability of the institution and the entity which is processing the data. For me, this shift is very well seen between the directive and the laws that were implementing the directive and the regulation. On one side, we had quite prescriptive law in many of the European countries, saying point after point what you have to do and what you shouldn't do. And at the same time, in the regulation, this attitude towards accountability is much more visible. And that is something that I welcome. On the other hand, I understand some fears or some at least reservations as far as the purpose limitation principle is concerned. But I have to say, yeah, this is one of the core issues that stays inside the fundamental right of the data protection, and something which is called in many countries of Europe information self-determination of the person. So the possibility to foresee for which purposes your data is used. We have to remember that the correlation between the different data does not mean at the same time causation. And well, there are some satiric examples of that, where the information about the fact if you put the felt parts under your furniture is used in order to assess your credit liability, because the person, it has been proved that there is some kind of correlation between the fact that you are trying to protect your floor against the furniture and the fact how you pay your credit obligations.
Okay, well, that's quite a unique example. Let me ask you, what is, in your opinion, legitimate public interest? And I'm going to ask you that as well, Jan.
Well, definitely legitimate public interest is one of the reasons for which the data is processed and one of the reasons that can be justified, because we have to remember that legitimate interest is definitely one of the bases for processing the data. The thing is, what does it mean, the public legitimate interest? If the public legitimate interest is the legitimate interest of the public body that is processing the data, then I would rather say that it's hard to imagine that the authority, that the administrative authority in the country is operating the same way as the commercial entity does. And once again, let me recall one of the last judgments of the Court of Justice of the European Union, which will be the Bara case, the Romanian case, where it has been said, yes, that might be the public interest for the authorities to process data and to transfer it from one authority to another, but there has to be clear legal basis and also all the respect to the fundamental rights of the persons.
Okay. Yeah, and this legitimate public interest, I mean, is that not just a massive loophole that would be a sort of get out of jail free card?
I think that we really have to be careful here, and we are still also looking into these provisions because one is to regulate the relationship between consumers and businesses. Both of them have legitimate interests and both of them have also fundamental rights which they can rely on their interests, and we have to reconcile that, and that is what data protection law does on the in the framework of, for example, the fundamental right to data protection in Article 8 of the Charter. We allow for data being processed if I consent to it, if I do a contract, you know, we can agree that this works. But between the citizens and the public authorities, the state, this is different because there is a power relation. I can't do a contract with the state about what's happening. The state has the power and it can and may use these powers, but only on the basis of legal provisions. That's how rule of law-based democracies work, especially when it's about intrusions into individuals' fundamental rights. So we have to assure that in each and every case where there is a legitimate interest of the public authority to process data, there's also a very specified legal provision laid down in law which allows for this to happen. There may not be just processing because somebody in the authority found it's useful.
Well, I mean, businesses are worried about this, but not just businesses. For example, yesterday there was an open letter from Cancer Research UK saying that they're very concerned that the right to use data and data mining for research purposes, which to cure cancer, which I guess that's a pretty good reason to use. But they're saying we can't prove before we do the research what the outcome will be. I mean, do you have any sympathy with that?
Absolutely, and I think that the research community has unfortunately replicated some misunderstandings throughout the last years, because it was not foreseen in the three texts that such research should be prohibited in any case. of course there are requirements for those research to be done. For example, the Parliament and also the Council, we foresee that if you do research with personalized data, you should pseudonymize. Of course, the research should try to keep separate individuals' data and the whole research data. And that's possible. You can do research in that circumstance. But you have to also to see, and I think that it needs to be better and more often explained to the research community, that we are allowing for quite a lot of research which at the moment on the basis of personal data in some of the member states is even not allowed. The Parliament says that you may, for example, give your consent in a more broader way for more purposes of research if there is such a research foreseen, so that you don't have to explain everything from the beginning in detail or foresee what you're doing in detail. The Parliament even also foresees that if there is a high public interest, that you can do processing, research processing, even without asking the individual. That's very far going. I mean, I imagine somebody going to my doctor saying, oh, I have a high public interest doing research on the data of Jan Albrecht's health status. I think that I should be asked. So we go very far, especially for those cases where we see that there is a real high interest of the public to solve public health questions, to solve research or problems by research, and we want to allow for that. And I think that we have to work together on a common provision. The difference is that research also, I think, has an interest that we don't say everything what's done out there which is statistical is research. Because then you would say the Google search algorithm could be some kind of research. So if we do that, then the specific treatment of research, the priority we give on the real research dilutes. It gets lost because you treat research in the same way like you treat Google. That would not be appropriate, and I think we should not make this mistake.
Okay. Well, I know that in a former life before you joined the EDPS, you worked in data analytics. What's your take on it? Can we trust those who are doing this sort of data mining not to go too far?
Yeah, that's true, that I have started my professional work as a data miner and as a person who was preparing the logic of data mining. And one thing I can say is that it's definitely fun. It definitely gives you a lot of fun to deal with the data. The mere fact that something is possible does not mean that we have to allow it. On the other hand, we have to be ready that the people will try to use the possibilities which are technically given. But nothing of what I said is said in order to stop the research itself. That's only to give the general basis for that and to give quite a reasonable way of dealing with the data that's concerned. That's the same thing like with the archives. Well, we understand that archiving the information is an important part, but there is a huge difference between the archiving for the public purposes in the public archives and archiving as general technique or the technologies that are in use. So also with the research, the very difficult question is who is the researcher and who is not. Well, I'm theoretically the member of academia, I'm the professor in the university, but I'm a lawyer and I'm doing my research in something which is not exactly a law. So this is something which is rather going to the knowledge management. Doesn't mean that I'm still the researcher and I'm still doing the scientific work. These are the questions which cannot be answered. If they cannot be answered, then there have to be some general background for the research to be done.
And who will this come down to making these decisions in the end? Will it be DPAs?
Well, first of all, it is the controller to do the decision. As I said, we are rather focused on accountability, which means that the controller has to be accountable for the things he or she does. And Data Protection Authority is one of the authorities to keep the eye on that, to see what's going on, and also to understand that's something which is a big challenge for data protection authorities, because some of the ways of processing the data cannot be really understood by the so-called data subject, means human being, you really have to have the specialist knowledge in order to know what is actually going on and what are the pros and cons of this solution. So data protection authority is at the same time the watchdog and the enforcer only in these situations which are really important and which are really necessary.
Okay, well, you mentioned human beings, and I heard a phrase recently that was quite horrific, which is consent fatigue. Now, I don't imagine I would ever get tired of being asked if I want to exercise my fundamental rights, but I suppose this has come about because of the idea of, say, with the cookie directive, where that boxes pop up all over your computer saying, do you want this piece of code on your computer? Is there going to be a situation where people just get sick of, oh, tick the box, do whatever you want? And if that becomes a case of, you know, we all just tick these, I've read the terms and conditions, when we haven't, are we actually really, in practice, having our fundamental right to data protection respected?
I mean, we all suffer this situation. We all are in this transition where we learn more and more what's happening, but we also like know about things, and we don't want to be reminded about things again and again. But I also have to say that the vast majority out there, also including myself, we learn with those situations. I mean, now with the cookie issue, everybody seems to be annoyed, me including, about the mere amount of questions I will get again and again. But the fact that this is happening brings to my awareness that there are cookies processing my data for certain reasons and for several purposes, and I should somehow deal with this personally, because it's a fundamental right. But I also think we have to deliver solutions for the future. It's not only a learning process on the side of the individual, but also it's a learning process between the politics, the authorities, the companies, about can we find a better way in the future. And yes, there are opportunities. For example, the proposals by the Parliament in the GDPR to say provisions, the long texts, lawyer language provisions, which I always have read and accepted, they should be displayed also in the form of standardized symbols in the future, so that I can really have information which makes a difference for me, and not just annoying and I don't understand and I just click it away. And the other proposal by the Parliament is, for example, introducing the legal environment for technical standards, not only for symbols but also for signals, which means that I can communicate in a more easy way as an individual with my opponent in this situation, my contractor, what my preferences are. The so-called do not track signal, which solves also in the future perhaps the situation of the cookie tracking, or which could solve that. At least for allowing for a standardized signal which I can give with my browser, with my mobile phone, wherever it is possible, actively from my side to indicate, okay, I'm fine with this, I'm not fine with this. All those situations, at least where there is the possibility for an opt-out. And of course, giving consent requires a bit more awareness, but we still can also work in the future also on how we can deal with this on a technical level.
Okay. Well, we haven't talked about third country transfers, and I want to ask you both, to what degree has the recent ruling in the Max Schrems case changed things? I mean, this has come in the middle of trilogue. Has it changed things? Has it shaken things up?
It was clear from the beginning for Parliament and Council and the Commission, I think too, that there would be a judgment by the court in a certain time frame. We didn't know when the court will issue this judgment, so it was not really clear if we would have to close the regulation before it comes. So when we negotiated also on the international transfer chapter, it was clear that if there would be something issued by the court, we would have to come back to it to reconsider if the text still is in line with what the court says, not because the law would have to respect that, because the judgment goes over it anyway, but in order to allow for such a regulation to also show what is the state of the legal situation in Europe. And we are negotiating on exactly that now, especially with regard to these adequacy decisions done by the Commission. The Parliament still thinks that it should play also a more important role in those decisions done by the Commission, but at least that the standard of protection which the Court has formulated, so that the European Union law by nature also requires a high level of protection and aims a high level of protection not only inside the European Union but also outside, that we should also respect that in our laws and make it effective in that way. And that's what we are discussing. For the consumer, of course, the situation hasn't changed yet, but that's on the side of the authorities now to see if either the Commission comes up with the new framework for transfers under an adequacy decision to the United States, or they have to find a way how to accommodate the standard of the Court in the other transfer opportunities which are there.
I mean, this is difficult because at the moment the US doesn't meet the adequacy standards, and really DPAs are now more empowered to look into complaints regarding this, but you can't force the NSA not to snoop.
Well, you have to remember that the first safe harbor agreement, so-called safe harbor agreement, and the decision by the Commission has been actually caused by the fact that there was expectations that in some years United States will meet the requirements that were laid in the directive, and safe harbor solution was meant to be the provisoric solution for some years until this standard is met. I have to first admit that the situation in the United States differs from the one that it was in the beginning of this century. And some of the changes are the changes in the good direction, and we can expect some new changes in the nearest future. At the same time, I have to say that the solution which is similar, I'm not saying about technicalities, but which is similar to safe harbor, is something that probably will have to be expected in the future, because the other alternative is to watering down the regulation. And this is something that I don't want. I don't want to have the softer law in the regulation, and at the same time the general decision that we treat United States and the companies in the United States the same way we do with Azerbaijan or Iran. We can see the differences between the level of the protection of fundamental rights in these countries, and we can understand that some of the solutions can be made, especially from some countries, for example for United States. At the same time, right now the ball is on the American side. Definitely they have to show that they are going into the direction that has been shown last few years by the activities of Federal Trade Commission as well. But this activity was only devoted to the commercial market, because that's where the FTC can do. Now we have to expect the same steps as far as the processing of the data by public administration is concerned.
Well, I mean, the GDPR, of course, also only applies to the commercial end of things.
Not really. We also apply the regulation to public authorities. But if I may add to exactly what has been said, it is really an issue that the Europeans have to push a bit more also, the United States government, to implement better harmonized standards also for the US market on consumer privacy laws, and there have been tries in the last years to do that, to strengthen also the oversight of the FTC, the Federal Trade Commission, over businesses. But in the public sector, of course, the problem is also that at the moment still, European citizens, they don't have even judicial redress possibilities, which now hopefully will be changed by Congress. So we see these steps. But nonetheless, I don't think that it is legally possible that the Commission now just tries to fix the situation by a new safe harbor. There needs to be legal changes in the United States law, because we can't change it from here. We can't change in Europe US laws. It's on their side to change it. But of course, when talking about this and blaming the US for not adhering to the standard of the European Court of Justice, which is one we cannot divert from, we also have to say that our own member states in certain areas also don't do, because they have carved out themselves in the area of national security. And we can just see these days, like the BND in Germany, which just spies on diplomats, even German diplomats in the European diplomatic service. That's not something which allows for us to say that here is the standard of the court respected, and that means it has to be changed also in Europe. We need to work together on a better protection of privacy and data protection in the area of public security and national security.
That's also something which deals with the directive, which is the second part of the package. 3 years ago, there was an interparliamentary meeting of the LIBE committee with the parliaments of the member states, and I had an opportunity to talk at this time about the directive, saying that having the directive in the law enforcement area is actually the condition sine qua non to go to big data with the public authorities. And it deals with the powers of the police and secret services, but also the other bodies which are dealing with national security.
Well, what I wanted to mention was, as I say, the commercial market. Businesses, for example, Microsoft has just said, we are going to store our data in Germany. So, I mean, is data localization a way that these sort of transatlantic businesses might be able to protect better European citizens?
I mean, I'm not a friend of this talk about let's like fragmentize the market or do like the German or European cloud in a way that we try to close the door or something. We need to have the doors open because we have a global market and we have a global digital sphere. But still, we need to assure that on this global market, our own laws are not just erased. We have to still insist that our own laws are applied. Whenever, for example, a service is offered to the European market, they have to comply with it. And if they want to not be storing data in Europe, for example, they have to push for other states in the world to also adhere to the high standards of the European Union. It's a good way to do it. And I think Microsoft is also a good example of a company doing both. They go to court in the US against the provision that they have to give out the data from Ireland to the United States, which they store in Ireland. But they also store data in Germany because they know if they store it there, then they have more or less the gold standard of the European data protection oversight and laws in their house, and they can offer it wherever in the world, so they don't have to deal with the issue anymore. That's good. I think we have to invest more on this as a positive instrument also.
I mean, is there a danger of forum shopping in the sense that businesses will find a place where a particular DPA is known to have a particular rigorous nature?
Definitely such a danger existed, and it existed under the directive. It exists with the drafts that are right now on the table. But once again, let me say that these coordination procedures between DPAs are mainly directed to this subject as well. I told you about so-called negative and positive conflict that may exist between the data protection authorities, and that goes exactly to this point. We are absolutely aware of the fact that there are data protection authorities in Europe who employ 380 people in the office, and they really have resources to deal with all the subjects. And we also have small countries where the DPAs are just few persons working in the one building. And some of them, even if these are small countries, might be the really very good place to have a business. And Luxembourg and Malta are the very good examples of that. So we have Luxembourg, which is quite a tiny country with a small data protection authority, by the way, quite an active one, yeah. But at the same time, a lot of big businesses having a place there. And definitely one of the things that we would like to avoid as the data protection authorities is the kind of game that you can play between us, between all those who are dealing with the enforcement. That's why the coordination procedures inside the European Data Protection Board has been established.
Okay. Well, a final question then to both of you. Hopes and fears for the next 6-month period on this?
Well, my hopes definitely are that the calendar will be kept, and in the half of next year we will have the documents ready, and in 2018 we will be able to start with the real activities. The fears, I guess only something unpredictable or almost unpredictable may change the situation. I hope nothing like that will happen in the nearest future, and at least will not be used against the really very good work that have been done here in the Parliament, in the Council, but also in the Commission with the first draft that was prepared by the Commission.
Okay, and Jan?
I'd like to echo that. I think that's exactly what we have to expect, and I'm quite optimistic that the good expectations we have with regard to the rules to be adopted, that they will be there and that they will be fulfilled. I also fear that we sometimes lose faith or courage and pressure just from tiny reasons, just from waves of anxiousness about the situation that we are in a global world, that all of this is of course also very important for economy and for security and other stuff. We have to insist again and again to all of us that data protection and growth and innovation and data protection and security and trust, they go together, that they are one of each other. They are together, and that's important that we remind us again and again to this, to avoid these fears to like overturn our good work here.
Okay, well, thank you both very much. No doubt we will be back to talk about the directive and e-privacy and PNR and so on in the future. And thank you very much for watching. That's it for our discussion on the GDPR. But if you missed the beginning, don't worry, you can see the highlights on ViEUws.eu. So do stay looking around the website, where you can also see briefings on various other areas, including the environment, transport and trade.